If you own a home and you're over 62, your house may already be affected by 3 rules that changed recently. And if you don't know what they mean, the cost can be your equity, your monthly cash flow, or even the home itself. These changes are already in effect and already being applied, but most homeowners were never given a plain English explanation. Stay with me, because by the end of this video, you'll know exactly what shifted and what to do about each rule this week. And don't skip number 3. Many seniors miss money simply because they didn't file the right paperwork. On this channel, I focus on the real financial information that affects seniors directly, the rules that change, the protections you may already qualify for, and the steps that can actually make a difference. If that's the kind of information you want, subscribe and turn on notifications. Now let's get into it. The frustrating part is that these rules aren't necessarily hidden. Banks, services, Medicaid offices, and county offices simply aren't sitting you down and explaining every change. So the power comes back to you when you know what to ask, what to file, and what to get in writing. This matters whether you're struggling to make ends meet or sitting on substantial home equity. You're not automatically exempt just because you're financially comfortable. Number 1 is the reverse mortgage eligibility and spouse protection update. If you have a home equity conversion mortgage, or you're considering one, 2 things change that directly affect how much you can access and who's protected if something happens to you. A higher federal lending limit can mean more borrowing power against a higher value home. But the bigger issue can be the spouse. Recent guidance narrowed who can be listed as a borrower based on residency status. At the same time, protection for a younger spouse who isn't on the loan was tightened if the borrowing spouse passes away first. Marriage alone doesn't guarantee this protection. The non-borrowing spouse designation must be requested and certified correctly, and it typically has to be reaffirmed with the servicer each year. And here's the expensive option first. Assume everything is already covered because someone told you verbally that your spouse will be fine. That's not a protection you want to gamble your house on. Walter learned that the hard way. He's 74, and his wife Ruth is 68. They took out a reverse mortgage on their paid-off home 11 years ago. Walter was the only borrower, and the non-borrowing spouse certification was never filed. When Walter passed away last year, the servicer notified Ruth that the loan balance was due. She had no idea any of this was coming. Ruth is now working with a housing counselor to stay in the home. That situation might have been avoided. If the form had been filed, the right move is simple. If you already have one of these loans, call the loan servicer directly. Ask whether the non-borrowing spouse is on file and properly certified. Then, ask for the answer in writing. Don't settle for a verbal yes. Your pass or fail test is simple. If you can't produce the paperwork showing the protection, don't assume the protection exists. For lower income homeowners, the higher lending limit may make more equity accessible, but only if the spousal paperwork is handled correctly. For higher value homes, the updated cap can change how much of the home's worth factors into the loan. The verdict: don't assume. Verify it in writing. And stay with me, because Rule 2 affects homeowners who may have never connected Medicaid to their house at all. Number 2 is the Medicaid estate recovery and pre-death lien update. If you or a spouse ever receives Medicaid coverage for nursing home care or certain long-term care services, the state can seek repayment from your estate after you pass away. In some circumstances, it can also place a lien on your home while you're still alive. Here's what most people get wrong. They hear that their primary residence is generally treated as an exempt asset while they're applying for and receiving Medicaid, and they conclude the house is completely protected. It isn't. That exemption applies to eligibility, not recovery. Once care has been paid for, the state can file a claim against your estate, and depending on your state, that claim can attach directly to the home your family expected to inherit. The wrong assumption is believing that because the house was exempt from Medicaid eligibility, the state can never recover those costs. That's not how the rule works. Home equity limits vary by state, and a spouse who continues living in the home generally has protection under spousal impoverishment provisions. But here's the distinction that matters. That protection is about the spouse while alive. It does not automatically erase recovery once the home is sold or transferred. Dorothy is a good example. She's 81. Her husband received 2 years of nursing home care through Medicaid before he passed. Dorothy continued living in their home under spousal protections and assumed the matter was closed. It wasn't. The state had already recorded a claim tied to his care. When the home is eventually sold or transferred, that claim may come due from the estate. Dorothy simply wasn't told that recovery can outlive the person who received the care. So here's the right move. If you're a lower income homeowner, learn about the undue hardship waiver. Every state is required to offer one, and genuine financial hardship may support a reduction or waiver. If you're a more comfortable homeowner, the issue becomes planning before care is needed. Certain ownership structures and transfers made well before care begins can change what's reachable later, and timing matters enormously. Don't guess about that part. It's exactly the kind of decision worth reviewing with a qualified elder law attorney. Your pass or fail test is physical. Contact your state Medicaid office and ask whether an estate recovery claim or lien has actually been recorded against your property. Get the answer and the hardship process in writing. That's how you stop guessing. Now, before we get to the last one, here's the bigger pattern. Walter wasn't careless. Dorothy wasn't careless. They were dealing with rules nobody had personally explained to them. And number 3 is where that problem can become money leaving your pocket every single year. So stay with me. So here's what I want you to do. The benefits, the discounts, the assistance programs most seniors qualify for but never actually use. I gathered them all in one spot, organized by state and by program, so you don't have to dig through confusing government websites for hours. It's quick, it's straightforward, and any senior can find exactly what fits their situation. No matter what state you're in, there's help out there you're probably leaving on the table. It's called the Senior Exemption Playbook, and is sitting in the first pinned comment right under this video. Just tap it once and you'll have everything you need. Number 3 is the property tax relief expansion, and this is genuinely the one with the most upside if you catch it in time. A wave of states raised their senior property tax exemptions, freezes, and deferral programs this year. Some states increased the additional exemption amount available to homeowners over 65. Others raised the income limits that determine who qualifies for a tax freeze. A tax freeze locks your assessed value in place, so rising home prices don't drag your tax bill up with them. And a separate group of states expanded deferral programs. These let you postpone paying property taxes altogether while you live in the home. The deferred amount is collected later, usually with modest interest, when the home is eventually sold or passed on. Now here's what most people get wrong. They assume that if they qualify, the county automatically applies the benefit. It doesn't. Every single one requires you to file paperwork, usually through your county assessor, and usually with a deadline that comes once a year. Miss that window and you wait another 12 months for the same benefit you already qualified for. The expensive option is simply doing nothing and assuming the county will catch you. They may not. Arthur is 69 and lives outside Chicago. His property taxes climbed while his income stayed flat. He qualified for a senior freeze but didn't know it until a neighbor told him. He eventually filed but lost 2 years of savings because the application wasn't automatic. For lower income homeowners, deferrals can free up monthly cash flow. For more comfortable homeowners, exemptions and freezes may still apply regardless of equity. These programs won't erase every property tax bill. They vary by state, and eligibility differs. But you can verify your own situation without guessing. Call your county assessor's office and ask what senior exemptions, freezes, or deferral programs exist for your age and income. The thresholds changed this year in a number of states. You may qualify now even if you didn't before. If they say you qualify, ask what paperwork is required and what the annual deadline is. Then look at the results yourself. You should be able to see the exemption, freeze, or deferral reflected in your records. That's your pass or fail test. If nothing has changed on paper, don't assume it was applied. The verdict, qualifying isn't enough. File it. Now let's turn all 3 rules into a simple 4-step checklist you can handle this week. Step 1, call your reverse mortgage servicer if you have one. Confirm in writing whether a non-borrowing spouse is properly certified on file. Step 2, if you or a spouse has ever used Medicaid for long-term care, contact your state Medicaid office. Ask specifically whether an estate recovery claim or a lien has been recorded against your property. Then ask what the hardship waiver process looks like in your state. Step 3, contact your county assessor's office. Ask directly what senior exemptions, freezes, or deferral programs exist for your age and income. The eligibility thresholds changed this year in a number of states, so you may qualify now even if you didn't before. Step 4, keep a folder, physical or digital, with every notice, every filing confirmation, and every phone call date connected to your home. That folder matters because a clear record can speed up a dispute. And here's what I don't want you to misunderstand. None of these rules are secret, but none are simply handed to you either. Your reverse mortgage servicer may not remind you about annual spousal certification. Medicaid may not send a reminder about a lien, and the assessor may not call when you become newly eligible. So the responsibility falls on you to ask, file, and follow up. That's why so many homeowners find out too late. Nobody's job is to personally walk you through them. And that's the real thread. None of them did anything wrong. They just weren't told. By the time they found out, some of what they lost couldn't be undone. You're not in that position anymore. You know what to ask for, you know who to call, and you know which forms actually matter. Now here's the simple recap. Reverse mortgage, verify the non-borrowing spouse certification in writing. Medicaid, long-term care, ask whether an estate recovery claim or lien exists, and ask about the hardship waiver. Property taxes, call the county assessor and ask what senior exemptions, freezes, or deferral programs you can file for this year. 3 calls, the right questions, the paperwork in your own folder. That's not just about saving money. It's about keeping control of the home you've worked for, protecting the equity you've built, and making sure your family isn't blindsided later because nobody explained a form. Tell me in the comments, which one of these rules was completely new to you, and which one are you going to check first? I read every single one, and in the next video, we're going deeper into the documents seniors should keep around the house, because one missing piece of paper can change what happens when your family needs it most. Before you leave, make the first call and get the answer in writing. I'm not a licensed expert, so make sure to check all of this information with verified sources, your servicer, your state Medicaid office, and your county assessor before you make any decisions about your home.